The judge read the verdict at 2:33 p.m. Not guilty. I wrote it down. I always write them down. Every verdict, every case, in real time, on a yellow legal pad, the moment the words leave the judge's mouth. I have done this since 1997 when a court reporter in Division 3 transposed guilty and not guilty in a certified transcript, and my client nearly went to Cummins Unit on a paperwork error. After that, I started keeping my own record. 26 years of verdicts in my own handwriting, stored in filing cabinets in my home office, one pad after another in chronological order. They have never been wrong. The certified transcript of State v. Darnell Watts says guilty. So does the minute entry. So does the disposition order. So does the CourtSmart digital recording. The one time-stamped at 2:37 p.m., 4 minutes after the verdict I heard with my own ears in a courtroom that was empty by 2:35. I need to go back to the beginning. The Watts case landed on my desk in March of 2007. Appointed counsel, Watts couldn't afford private representation, and the public defender's office had a conflict because the victim's cousin worked in their records department. Standard conflict referral. I got the file on a Tuesday. It was thin. That was the first thing I noticed. A second-degree murder file should have weight to it. Witness statements, forensic reports, photographs, medical examiner's findings. The Watts file was maybe 40 pages. A bar fight outside a pool hall on West Roosevelt Road. 2 men arguing over a tab. 1 punch. The victim, Marcus Hendley, 34, fell backward, hit his head on the curb, and died at Baptist Medical Center 6 hours later. Single blunt force trauma to the occipital region. No weapon, no prior threats, no premeditation anyone could prove. The prosecution's theory was intent. Watts threw the punch knowing it could kill. My theory was accident. A drunk man swung once and got unlucky. In 26 years, I've handled maybe 40 cases like this. Most of them plead down to manslaughter. Some go to trial. None of them keep me up at night. I met Watts at the Pulaski County Detention Center the following Thursday. He was 31, soft-spoken, worked at a transmission shop on Cantrell Road. No prior felonies. 1 misdemeanor DWI from 2003 disposed with a fine. He told me what happened the same way 3 separate witnesses told the police. An argument, a push, a punch, a fall. He wasn't hiding anything. He just wanted to know if he was going to prison. I told him the truth. With a decent plea offer, maybe not. The DA's office had been floating voluntary manslaughter, 8 years. Served 4. It wasn't great, but it was survivable. Watts said no. He didn't want a plea. He wanted a trial. Not a jury trial, a bench trial. Just the judge. He said he didn't trust 12 strangers to understand that 1 punch doesn't make you a murderer. He wanted 1 person to look at the evidence and decide. I filed the jury waiver the next week. Judge Harold Oren was assigned. Division 5. I'd tried 32 cases in front of Oren over the years. He was methodical, slow, read every exhibit before ruling on objections, never raised his voice, never surprised you. He was the kind of judge who made the law feel like what it was supposed to be, a system of procedures that, if followed correctly, produced reliable outcomes. The trial started on a Monday in October, 4 days. The prosecution put on their case. The responding officer, 2 bar patrons who saw the punch, the medical examiner. I cross-examined on the question of intent. Had the ME ever seen accidental death from a single punch? Yes, 7 times in her career. Could she determine intent from the injury? No. Did the trajectory suggest a planned strike or a reactive one? She couldn't say. I put Watts on the stand on day 3. He was honest. He admitted the punch. He said he was drunk and angry and scared, and the moment his fists connected, he knew he'd made the worst mistake of his life. He cried on the stand, not for show. I've seen enough defendants perform and enough defendants break. Watts broke. Day 4 was closings. The ADA gave a tight, competent argument about accountability. I gave mine about the difference between a tragedy and a murder. Judge Orrin took a 45-minute recess. When he came back, the courtroom was quiet. Just me, Watts, the ADA, the court reporter, Linda Fay, who'd been reporting in Division 5 for 19 years, the bailiff, and a clerk seated near the bench. Orrin read from a single sheet of paper. I remember the paper. White, unlined, his handwriting visible from counsel's table but not legible at that distance. He adjusted his reading glasses. He said the standard preamble. The court having considered the evidence presented, the testimony of witnesses, the arguments of counsel. Then he said it. The court finds the defendant not guilty of the charge of murder in the second degree. I wrote it down, not guilty. Yellow legal pad, blue ink, my handwriting. I underlined it once, the way I always do with acquittals. I wrote the time next to it, 2:33 p.m. Watts exhaled like a man who'd been holding his breath for 7 months. I shook his hand. The ADA closed her file, no visible reaction, professional, and left through the side door. The bailiff walked Watts to the clerk's window for release paperwork. Linda Fay was packing up her stenotype machine. I put my legal pad in my briefcase, along with my copy of the case file, and I walked out of the courtroom. I was in the elevator by 2:35. I remember because I checked my watch. I had a 3:15 client meeting back at the office, and I needed to stop for gas. I did not go back to the clerk's office that day. I had no reason to. The certified disposition order would be ready the next morning. I'd pick it up then, file it, close the case, send Watts a letter confirming the outcome, and move on to the next file. That's what should have happened. Friday morning. I walked into the clerk's office on the first floor at 8:40 a.m. The deputy clerk, woman named Sandra, had been there 12 years, pulled the Watts file. She handed me the disposition order. It said guilty, murder in the second degree. Sentence, 20 years, Arkansas Department of Correction, Judge Harold Orrin's signature at the bottom, dated the previous day, Thursday. The day I'd sat in that courtroom and heard the word not. The day I'd written not guilty on my legal pad and underlined it. I looked at Sandra. I asked her to check the minute entry. She turned her monitor toward me. The minute entry, the clerk's contemporaneous record of court proceedings, read, verdict guilty, sentence 20 years ADC. I asked her to check the docket sheet. She flipped to it. Disposition guilty. I said there had been a mistake, that the judge had read not guilty, that I was in the courtroom and heard it. Sandra looked at me the way clerks look at lawyers who are having a bad morning, patient, a little tired, not unkind. She said she could only go by what was in the file. If I believed there was an error, I should file a motion to correct the record. I stood there holding the guilty disposition order in one hand and my briefcase with my yellow legal pad inside it, with not guilty underlined in blue ink in the other. The courthouse coffee from the second-floor vending machine was sitting in my stomach like battery acid. The file was too light. That was the thought that kept circling. The Watts file had been too thin from the start, like a case that wasn't meant to hold together, like something built to look complete from the outside but hollow in the middle. I walked out of the clerk's office and called Judge Orrin's chambers from the payphone in the first-floor lobby. His judicial assistant answered. I told her I needed to speak with the judge about the Watts disposition. She put me on hold for 4 minutes. When she came back, she said the judge would see me at 11. I had 2 hours. I went to my car, opened my briefcase, and looked at my legal pad. Not guilty. Blue ink, my handwriting, underlined. I closed the briefcase and sat in the parking lot with the engine running, trying to figure out which record was wrong. The clerk's or mine. In 26 years, my legal pads had never been wrong. But in 26 years, the clerk's office had never produced a disposition order that contradicted what a judge said in open court. One of them had to be wrong. That was the part I still understood. That was the last moment anything about this case made sense. I was in Judge Oren's chambers at 11 sharp. He was behind his desk, reading, glasses on, a stack of case files to his left, a cup of coffee from the break room on a coaster his granddaughter had made. I'd seen it on his desk for years, ceramic with a crooked painted flower. He waved me to the chair across from him. I told him the disposition order said guilty. I told him the minute entry said guilty. I told him the docket sheet said guilty. I said it plainly, the way you present facts in a motion hearing, without argument. Then I said I was in the courtroom when he read the verdict, and the verdict was not guilty. Oren took off his glasses. He set them on the desk and rubbed the bridge of his nose. Then he opened his bench file. Judges keep their own working file during trial, separate from the court file, and pulled out a sheet of white unlined paper. His bench notes, his handwriting. The court finds the defendant not guilty. He turned the paper toward me so I could read it. His handwriting. The same sheet I'd watched him read from the day before. I remember what I said. Oren told me. I said not guilty. There's no ambiguity. So we had two records saying not guilty, my legal pad and the judge's bench notes, and every official court document saying guilty. In 26 years, I had never seen a discrepancy between a judge's bench notes and the clerk's minute entry. The clerk sits 3 feet from the bench. She hears the same words everyone hears. Oren called Sandra in. She brought the file. He showed her his bench notes. She looked at them, looked at the minute entry, and said, "I'll correct the entry, Judge." Like it was a typo. But it wasn't a typo. A typo is gilly instead of guilty. This was the opposite word. The difference between a man walking free and a man doing 20 years at Varner Unit. Sandra went to make the correction. Oren told me to check with the court reporter and file a motion to correct the record. Standard procedure. I left his chambers thinking the problem was solved. Clerical error. The county had been migrating from the old ACAP case management system to Context for 6 months, and Division 5 was a pilot courtroom. Double entry, parallel systems. Things fall through cracks. I went to see Linda Fay. Her office was on the 3rd floor. Small room, 2 desks, a filing cabinet, a window facing the parking garage. She'd been the court reporter in Division 5 for 19 years. Precise, meticulous, the kind of person who flagged it in the margin when a witness said February and meant January. I told her about the disposition order. She frowned. Then I asked her to pull the stenotype tape from the Watts trial, the raw paper tape from her machine, the source material she types the certified transcript from. She opened her filing cabinet and pulled the tape. Stenotype tape is a narrow strip of paper with coded shorthand. It looks like gibberish to anyone who hasn't been trained, but Linda could read it the way I read a case citation. She unrolled the section from the verdict reading. She read it out loud. The court finds the defendant not guilty, clear, unambiguous. On the raw tape in the machine's shorthand, the verdict was not guilty. Then I asked to see her certified transcript, the official document, the one that goes into the court file, the one that appellate courts rely on, the one that is the legal record of what happened in that courtroom. She pulled it up on her computer. Page 347 of the Watts trial transcript. She scrolled to the verdict. The court finds the defendant guilty of the charge of murder in the 2nd degree. Linda stared at her screen. Then she looked at the stenotype tape in her hand. Then back at the screen. She said, "I typed what was on the tape." She wasn't defensive. She wasn't confused. She was scared. I could see it in the way she held the tape, pinched between 2 fingers, away from her body, like evidence at a crime scene. She had typed that transcript from that tape. They didn't match. She had no explanation. She checked her log. She'd typed it Thursday evening, same day, the way she always did. She had no memory of the transcript saying anything different from the tape. But the tape said not guilty, and the transcript said guilty, and she'd typed one from the other. I left Linda's office with a photocopy of the stenotype tape and a printout of the transcript page. I put them in the Watts file. 2 documents, same source, opposite outcomes. I remember thinking, and I'm not proud of this, that it was almost elegant. The system was eating itself. ACAP, context, the stenotype, the transcript, the minute entry, the docket sheet, the disposition order, 6 different records, and the only ones that said not guilty were the 2 that no one would ever look at, the judge's personal bench notes and a strip of paper tape in a filing cabinet. That's when I found out about the CourtSmart recording. Division 5 had been one of 2 courtrooms in the building fitted with the CourtSmart digital recording system. It had been installed 11 weeks earlier, part of a statewide pilot program to create audio backups of court proceedings. The system ran automatically, 4 ceiling-mounted microphones, a dedicated hard drive, files indexed by case number and date. No one operated it. It just recorded. I went to the IT office in the basement. A technician named Carl pulled up the files for Watts. Case number 60CR7-1894, Thursday's date. There were 2 audio files. The first was timestamped 2:33 p.m., duration 47 seconds. I asked Carl to play it. Judge Oren's voice came through the desktop speakers, thin and slightly compressed by the recording. The standard preamble. Then the court finds the defendant not guilty of the charge of murder in the 2nd degree. The recording ended. The second file was timestamped 2:37 p.m., duration 52 seconds. Same preamble, same voice. The court finds the defendant guilty of the charge of murder in the 2nd degree. The defendant is hereby sentenced to 20 years in the Arkansas Department of Correction. Same judge, same courtroom, same case number, 4 minutes apart, but the courtroom was empty at 2:37. I was in the elevator at 2:35. The bailiff had walked Watts to the clerk's window for release processing. Linda Fay was packing up her stenotype machine. The ADA had left through the side door before I did. The courtroom was dark. I asked Carl to check the system log, who accessed the files when they were created. He pulled up the metadata. Both files were generated by the CourtSmart system. Both listed the source as the 4 ceiling microphones in Courtroom 5. Both were tagged with the case number automatically. The system didn't allow manual file creation. You couldn't record something separately and upload it. The files were created by the microphones in that room. Carl looked at me. Could the judge have gone back in and read it again? I had no answer to that, but I knew Oren hadn't. His bench notes said not guilty. He'd shown them to me in his chambers not 2 hours earlier. He remembered not guilty. Something in that courtroom recorded a guilty verdict at 2:37 p.m. on a Thursday in October in Judge Harold Oren's voice into a system that could only record what its microphones picked up in a room that had no one in it. I filed the emergency motion to correct the record that afternoon. Rule 60A, clerical mistakes. Oren signed the order granting it. The clerk's office received it before close of business. Sandra entered the correction into ACAP, not guilty. She saved it. She pulled the record back up to confirm, guilty. She entered it again, saved, pulled it up, guilty. She tried context. Same result. The system accepted the entry, saved it, and when the record was retrieved, it said guilty. 3 times in ACAP, twice in context. Sandra called IT. They couldn't explain it. They said the database was functioning normally. They said the entries were saving correctly. They said the retrieval was pulling the correct data. but every time anyone opened the Watts file, it said guilty. I drove home that evening with the case file on the passenger seat, my legal pad in my briefcase, and a copy of the judge's signed order granting the motion to correct sitting on top of the file. Not guilty, in the judge's handwriting, with his signature and the court seal. On the drive home, I kept checking the rearview mirror, but I wasn't looking for traffic. I was looking at the file on the seat beside me. I don't know what I expected. I don't know what I was afraid of. The smell of toner from the clerk's printer was still in my clothes. 5 copies of a disposition order that kept saying the wrong thing, printed one after another, while Sandra and I stood there watching the paper come out of the machine like a confession we never asked for. The weekend passed. I didn't sleep well either night. Saturday morning, I called Judge Oren's home number, something I had done maybe 3 times in 26 years, and only on cases where someone's liberty was at immediate risk. This qualified. I told him about the CourtSmart recordings, 2 files, 2 verdicts, 4 minutes apart, his voice on both. He was quiet for a long time. Then he said, "I read it once. I only read it once." I told him about the clerk's system, how every correction reverted to guilty. He said to bring everything to him Monday morning. He'd handle it from the bench. Monday morning. I was at the courthouse by 7:45. I went to the IT office first. I wanted copies of both CourtSmart recordings before anything else. Carl was at his desk. He pulled up the files for case number 60CR-7-1894. There was one file, timestamp 2:37 p.m., duration 52 seconds, the guilty verdict. The 2:33 p.m. file, the not guilty recording, the one I had listened to in this same office 3 days ago, was gone. I asked Carl what happened. He checked the system log. CourtSmart had a 72-hour buffer for temporary files, he said, and the system performed automatic maintenance on a rolling basis. The 233 file had been overwritten. I asked him to check the overwrite log, when exactly the file was deleted. He pulled up the maintenance record. The file was last accessed at 3:14 a.m. on Saturday. Accessed. Not overwritten by automated maintenance. Accessed. Someone or something had opened that file at 3 in the morning in an empty courthouse, and it had ceased to exist. Carl didn't have an explanation. He said the system wasn't set up for remote access. You had to be at a terminal in the building. There was no Saturday access logged for any courthouse employee. The building alarm system showed no entry between Friday 6:12 p.m. and Monday 5:40 a.m. One recording left, the guilty one, at 2:37 p.m. in an empty courtroom, in the judge's voice. I went upstairs. Before I saw the judge, I stopped at Linda Fay's office. I wanted the stenotype tape, the raw tape that said not guilty. The last physical record that matched what I'd heard. Linda told me she'd sent it to the State Records Center on Friday afternoon. Standard archival procedure for completed cases. I asked her to request it back. She made the call. The Records Center said they'd pull it and send it over. It arrived by courier at 11:30. The box was labeled correctly. Case number, date, division. I opened it with Linda. The tape was inside, coiled in a clear plastic bag. Linda unrolled it. She read the verdict section. The court finds the defendant guilty. She put the tape down on her desk. She looked at me. Then she started crying, not loudly. She pressed her hand over her mouth and her shoulders shook, and she said through her fingers, "That's not what it said. I read it on Friday. You were here. It said not guilty." I had been there. I had heard her read it. The tape had said not guilty on Friday. Now it said guilty. Same tape, same ink, same machine-printed shorthand. The physical tape had not been damaged, altered, or replaced. The serial number matched. The case number stamp was consistent. The paper stock was the same continuous roll from Linda's machine. I had taken a photograph of the tape on Friday. Cell phone. A habit. I'd started photographing key documents the year before, when I couldn't get a case file copied before the clerk's office closed. I pulled up my phone. I scrolled to Friday's photos. The photograph of the stenotype tape showed, "The court finds the defendant guilty." I was looking at a photo I had taken of a tape that said "not guilty." The photo said "guilty." I remembered taking it. I remembered what the tape said when I pointed my phone at it, "not guilty." 2 words. I can still hear Linda reading them aloud. I went to see Watts. He'd been rearrested Friday night. The certified transcript said guilty. The disposition order said guilty. The warrant had been issued based on the official record. By the time I got Oren's correction order signed on Friday afternoon, the arrest had already been processed. Watts was in the Pulaski County Jail in a holding cell on the 4th floor. I sat across from him in the attorney consultation room. The table was cold. The room smelled like disinfectant and the particular staleness of recycled air. Watts was in an orange jumpsuit. He looked at me without surprise. "The verdict was not guilty," I said. "The judge said not guilty." "I heard it. The judge remembers it. His bench notes say it. I'm going to fix this." Watts tilted his head slightly, the way a man does when he's deciding whether to correct someone or let it go. Then he said, "It was always guilty, counselor. You just heard it wrong." I told him that wasn't true. I told him I had my legal pad, my handwritten record, in my briefcase. I told him it said not guilty. He looked at me with something that wasn't pity exactly, more like patience. The kind of patience you show someone who doesn't understand a situation that's already been decided. He said, "Check it again." I opened my briefcase. I pulled out my yellow legal pad. I turned to the page. October 18, 2007. State v. Watts, 2:33 p.m. Not guilty. Blue ink. My handwriting. Underlined once. It was still there. The last record anywhere in the world that said what I heard. I held it up so Watts could see it. He looked at it for a long moment. Then he said, "That'll change too." The judge vacated the correction order Monday afternoon. Not because he wanted to, because the appellate division called his chambers and asked why he was attempting to modify a valid guilty verdict when the certified transcript, the minute entry, the docket sheet, the disposition order, and the CourtSmart recording all confirmed the same outcome. Oren told them there had been a different verdict. They asked him for documentation. He gave them his bench notes. They said bench notes were not part of the official record. Oren looked at me across his desk after the call. He still had his bench notes. They still said not guilty. But they were the personal notes of a trial judge, and they carried no legal weight against a certified transcript, a sealed minute entry, and a digital recording. "I don't know what to do," he said. In 30 years on the bench, I don't think Harold Oren had ever said those words. I went home that night. I put the Watts file on my desk. I took my yellow legal pad out of my briefcase and opened it to the Watts entry. Not guilty. Still there. I took a photograph with my phone. I watched the image appear on the screen. Not guilty. I put the phone on the charger. I put the legal pad in my desk drawer. I locked the drawer. That was Sunday. No, that was Monday night. 3 years ago. This is the tape recorder, last day in this office. Boxes are packed, filing cabinets are going into storage. I pulled the legal pad out of the locked drawer this morning to dictate this account. The entry for State v. Watts, October 18, 2007, reads, "Guilty." My handwriting, my blue ink, underlined once. I checked the phone photo, the one I took Monday night, the one where I watched the words appear on the screen. Guilty. Darnell Watts is serving year 3 of a 20-year sentence at Varner Unit for a verdict that Judge Harold Oren did not read. I was in the room. I heard what the judge said. Oren heard what the judge said. Linda Fay's fingers typed what the tape told them. And every record, Every tape, every transcript, every file, every digital system, every photograph, and now every mark I made with my own hand says something different. I'm leaving this tape in the filing cabinet with the legal pads. 26 years of verdicts, every one of them in my handwriting. They've never been wrong. I don't know if that's still true. If you're listening,